Welcome, everyone. My name is Mark Massa. I'm a Jesuit at Boston College. I'm a professor in the Theology department here at BC. And also I have the privilege of being the director of the Boisi Center for Religion and American Public Life, which does many things having to do with that broad intersection between religious impulses and beliefs and American politics, cultural mores, all kinds of other things as well. I'm pleased to introduce Dennis Wieboldt, an overachiever here at BC, who is both a joint bachelor and master's degree candidate in the history department and a bachelor's candidate in the theology department. Dennis has recently completed research into a project entitled The Natural Law Foundation of Interreligious Social Advocacy, a civil rights movement case study, through a generous grant by Boston College's Center for Christian Jewish Learning. Welcome, Dennis.
Hey, thanks so much for having me. Thank you also to the Center for Christian Jewish Learning, Dr. Camille Markey over there, who's helped with the grant. It's been a great experience.
Wonderful. So could you tell us a little bit about your project, both how the project started and what you found in doing the project?
Yeah, for sure. So the project initially started, I was taking a broad look at how Catholics and Jews cooperated during the civil rights movement. As I got through the secondary literature, I came across, actually by recommendation from one of the archivists at the Burns Library at BC, the William J. Keneally papers. He was a former dean of the Boston College Law School, a Jesuit as well. And it was interesting because his papers have only recently kind of been brought to light, recently cataloged and such. So as I took a look at his papers, I found really interesting the way in which he used the natural law as a way to build interreligious partnerships that promoted racial equality. So I think, especially given everything that's gone on in the last few years in the US, and the role that we've seen now with a Catholic president and the role of Catholics in the public square, I thought it was interesting to kind of take a case study in how a concept, the natural law, which seems antiquated now, typically seen as something that can be exclusive, how that was used in a much different way. And that kind of, formed the basis for the research.
No, as you and I both know from previous conversations, natural law is a large sinkhole into which all of us could disappear pretty much without any appearance for many months at a time. In 2 sentences, can you tell us what you take to be natural law and why it's not surprising that this Jesuit priest used natural law in his arguments?
Yeah, for sure. So I think Keneally's presentation of the natural law had 2 big parts. First, that it was available to everyone through pure reason, irrespective of their religious commitments. Actually, I'll say 3 things. Secondly, that it required working for the common good, and thirdly, that the natural law creates an objective moral order to which all civil law must abide. So in this case, obviously, what he found to be repulsive to the natural law was government-mandated segregation and discrimination more broadly.
Now, also besides being a Catholic thing, natural law is also a constitutional thing, sort of utilized by our founders in writing both the Constitution and the Bill of Rights. Could you explain, the way our founders talked about natural law is somewhat different than the way, say, St. Thomas Aquinas talks about natural law. What do they have in common, and why was it a useful vehicle for Keneally?
Yeah, certainly. I think I might have to do another whole project on that. But even if you look in the Declaration, some of the first few lines appeal to the natural law, and obviously it's a very contentious part of history because you have some who say some who advocate the position of the Christian founding, and then some who say we have a secular founding, and there's got to be something in the middle. But I think the extent to which the founders acknowledge, and I think this is still a historical question up for debate, the extent to which the founders envisioned the Constitution as respecting a higher moral order. Obviously, and I say this in my paper, the difficulty there, and part of my paper for those who don't read it before this, I start off with introducing a theoretical framework that Professor Kathy Caveney at BC has written about in her recent book. And basically what I talk about there is how the relationship between the American legal tradition and kind of those broader moral appeals. So I think for this research, the important part was that relationship between equality, and then obviously in the Constitution there was a defense of slavery. So there's clearly tension there, and how that tension got worked out, especially during the Civil Rights Movement. That's the interesting piece I take a look at.
Right. Now, so everybody agrees that the most common interpretation of the Constitution, when the founders wrote, "We hold these truths to be self-evident," that's always taken as a classic natural law statement, because implied in that statement is that anybody using their reason, anyone of reasonable intelligence and good intention, using their reason, can understand these truths, which are life, liberty, pursuit of happiness, and so forth. Was it surprising to you that a Catholic priest using natural law, which by the 1950s and 60s was pretty much just a Catholic preserve, could come up with an argument that Jewish Americans would also find attractive? Was that a surprising part of your project?
Yeah, a massive surprise is an understatement. If you take it, and part of the beauty about Keneally and what's been preserved of his legacy is that he has a lot of personal correspondence. I think of all other religious traditions, he probably worked most with Jews, especially in and around BC during his time here. But there are letters from Episcopalians. There's a letter from a Unitarian. There's all types of different things. But what makes his work so interesting, in particular, is he had a long-standing colloquy in various law reviews with a professor at the University of Illinois and later Hastings College, where they really debated quite fiercely the existence of the natural law and whether it had any bearing on the US. And what's interesting is after Keneally gave a sermon, a 1956 Red Mass sermon, which kind of I use as the foundation for how Keneally approached these issues, Keneally got a letter from Professor Wieboldt complimenting Keneally on his presentation of the natural law and the way in which to use that to support an argument for racial equality. This isn't to say that Wieboldt endorsed his theory of the natural law. He continued to reject it. But the way that Keneally was able to present it it was almost an invitation for people to take it if you wanted it, but if not, it still exists. So that's the interesting piece there.
Just back up just a little bit. Tell us what the Red Mass is and why the fact that Keneally outlined this at a Red Mass is an important event.
Yeah, so Red Masses have a long history. It kind of began in Europe, and it basically it inaugurates the new legal year, so to speak. So Keneally, he had been the dean of BC law for a couple, I think 2 decades almost. And then in 1956, he took a visiting professorship in Louisiana at Loyola University, New Orleans. And one of his biggest assignments while he was there was to give this Red Mass sermon. And he described it as in front of the bench and bar of Louisiana. So not all Catholics. And we have to remember the context here. This is in Louisiana, the South, and he knew that it was going to be a provocative sermon for a Southern audience. It's written in some of his correspondence. But he gives it with Archbishop Rummel presiding over the Mass. Archbishop Rummel was the Archbishop of New Orleans. He was well known for his civil rights work. There's actually a very detailed history that was published a few years ago in one of the journals about Archbishop Rummel and kind of the New Orleans area. But in the Red Mass sermon, Keneally takes, he very specifically lays out what the natural law means for racial equality and how that should relate to the people who he's speaking to. And those are not all Catholics. And basically what he says is, look, it's the responsibility of judges and lawyers to make sure that our civil law respects the natural law. And because the natural law tells us that, Americans of all colors are equal, we need to fill in that gap.
So what kind of pushback to that Red Mass sermon did Keneally get? Did most people applaud him? Did most people attack him? What was the response?
Yeah, so certainly, there was a very good response to those who probably were going to agree with him anyway. So we need to kind of contextualize that. There were certainly people who disagreed with him. It was funny, a few years later, there was a KKK aligned group that actually wrote a scathing anti-Catholic, anti-Semitic, newspaper clipping type of thing that I didn't even get to mention because of space. But not everyone liked what he had to say. However, those who, as the problem with any intellectual history, it's difficult to ascertain the exact impact of, any figure on any one person. But what you see from the correspondence, his public writing subsequently, and, his invitation, he was getting invitations all over the country to, speak on panels, Interreligious, et cetera. So that reaction was positive, and that, I think, told Keneally that my presentation here, the way I'm using the natural law, these appeals I'm making are working, and they're appealing to an interreligious audience. So you see from the 1956 Red Mass sermon through kind of my piece ends in the early 1960s, that entire time, he's really recycling these same ideas from that sermon. And he didn't invent them. I don't want to spruce him up too much. But I think it's important to note that he didn't really change those fundamental appeals that he made from 1956 on.
So walk us through the basic argument of your thesis. So you discovered this Jesuit named Keneally, who was at BC Law School, in fact, served as a dean of BC Law School, and then became sort of a national figure at using the natural law argument to argue for civil rights and social justice, which received a fairly positive and broad national response to this. So walk us through. So why should people rush out and read your thesis?
So I think so basically my fundamental argument is Keneally's 1956 Red Mass sermon charts out how he uses the natural law to defend the objective truth of racial equality, and that these ideas eventually become evident in what the U.S. Catholic Bishops' Conference, the predecessor, kind of the pre-predecessor to the USCCB today, their 1958 pastoral letter.
We can't assume that everybody's familiar with Catholic Church politics. So explain what the USCCB is, what that stands for, and what it is.
The United States Conference of Catholic Bishops, which is basically the governing kind of body of bishops in the United States. So in 1958, the National Catholic Welfare Conference, which was one of the predecessors to the USCCB, they published a pastoral letter entitled "Discrimination in Christian Conscience." And they really recycle again the ideas that Keneally was talking about years earlier. And there's no smoking gun to connect them. But what the evidence shows is that Keneally knew these bishops. He was writing back and forth with them. They were familiar with his work. So the fact that Keneally's presentation of the natural law, the way he used appeals to the common good, the fact that that made it into a major statement of the American hierarchy that predated the Civil Rights Act of 1964, and the way Catholics would approach that, I think that's that's something important that we should definitely take a look at. And to your point about kind of national versus local, et cetera, one of the interesting thing is, I think especially recently we've seen more scholarship moving kind of the history of the civil rights towards some of those more local leaders who didn't always receive the headline on Time magazine as John Courtney Murray and others might have. The interesting thing with Keneally is he also wasn't one to make the national press much. There was a couple of references a little bit later in his life to it, but at the same time, he's getting letters from people all around the country who somehow are finding his work, whether that be through a Catholic magazine, whether that be through a show on the air. So he did build a reputation for himself, and even later debated William Buckley, famously of the National Review. So he definitely had some impact in the way in which Catholics, regular lay people, approach these issues.
So what about natural law? Began, as you and I know, actually in Greek philosophy. Both Plato and Aristotle argued that there is a law that is actually before nations. There's a law more fundamental than positive law, that is humanly made law, that can be found in nature. That's the basic Greek philosophical argument. And the Catholic Church, especially St. Thomas Aquinas, took over that argument. And St. Thomas, who was condemned by the church actually in 1277 for doing this, because he was using a Greek pagan philosophical thing, but it eventually wins. It becomes the way that Catholics talk about basic rights. And so the presupposition there inherent in natural law is not religious. The presupposition there is that the natural law has no religious presuppositions, that anybody using their reason can discern, can discover in the real world that everyone's created equal, that people have basic rights, whether the state gives it to them or not. So why was, or perhaps instead of why, do you think that non-Christians, specifically say American Jewish citizens, would find Keneally's argument interesting and compelling or not? Because while originally natural law had no religious connotations, for 1,000 years it was primarily a Catholic way of speaking about rights. Did it seem to have appeal to non-Christians?
Yeah, it certainly did. And I mean, there's Keneally, as I said earlier, he participated in interreligious panels. He was invited by the president of the Union of American Hebrew Congregations, which is now the Union for Reform Judaism, to do presentations. And, there are even some letters noting that when Keneally was discussing with those of other religious traditions, certain issues, whether that be later in his life, it was more on church and state, so issues of public funding for education, et cetera. People would say, look, Keneally disagreed with people in very real ways, and yet he was always agreeable, and people always were able to take something away from that. So I think to the extent that Keneally's, continued presence in interreligious collaboration throughout his tenure post 1956, the fact that those invitations, those accolades continue to pile up, I think that shows that what he had said and the way he presented it, that was attractive even to non-Catholics or non-Christians for that matter.
Okay, great. So I know the last part of your paper is entitled "The Natural Law in 1963." Why the 1963 drop dead date? No pun intended here. And what happens to natural law in the 20th century, especially as figures like John Courtney Murray, another famous Jesuit, who wrote a book sort of basically arguing why Americans should elect John Kennedy as the president. Why 1963?
Yeah, I'll be honest, part of it was space. I ran out of space. But really, I chose 1963 as opposed to another date is because in 1963, the National Conference on Religion and Race, which was a major interreligious group that eventually, I believe, met in Chicago, they published what was called the Appeal to Conscience. And this was a major statement of Protestants, Catholics, and Jews primarily, talking about racial equality and why those who are or of religious dispositions should support it. I picked that date because I think 1963, obviously before the Civil Rights Act is passed, that's a major moment in the civil rights movement, especially in terms of religious advocacy. And what we see also, and I didn't discuss this in the paper, but they're the same thread from Keneally's 1956 sermon through to the 1958 statement of the National Catholic Welfare Conference, through Keneally's subsequent public, statements and private writings, through all the way to the 1963 Appeal to Conscience. What we see is the same or very similar appeals, and the same way that Catholics are able to use the natural law in this productive way. And kind of that, my conclusion has a provocative title, The Natural Law in 1963. And because, I think in the 1960s, once Humana Vitae gets published, as you've written about, many times, the natural law seems like an antiquated topic, and yet it was still effective for Keneally and others. So I think that raises an interesting question for historians still. And, perhaps I'll write something separately on the National Conference on Religion and Race, because I think that's also an important connection.
Great. Well, thank you. It sounds like a very interesting project, Dennis. And it sounds like it was a project more than worthwhile.
Absolutely. Yeah.
And our joint thanks to the Boston College Center for Christian Jewish Learning, which made your project possible and enabled you to have the time and the resources to pursue this. So blessings on your work. And I urge people to run out and see this before it's a made-for-TV movie, okay?
Thank you very much. And thanks also to the Center for Christian Jewish Learning, Kathleen Monahan, and the Burns, the staff at Burns, all great helps.